Hello everyone, welcome you back to our channel. This is the Go Mindset Adeba, and today we are going in for a good and core topic in legal methods. It's also a topic in 1.1 Introduction to Law, the doctrine of precedents. So by the end of this session, you should be defined and knowable and be able to describe what the doctrine of precedent is. You should be able to give the types of precedents. You should be able to give the way our courts avoid to follow a precedent. You should also be able to give the advantages and disadvantages of the doctrine of precedent as a modern day student. So to dive into it, I beg you to subscribe such that we can continue with our topic. So, the doctrine of precedent means that a judgment or decision cited so as to justify a decision in a later similar case. Here is an alternative. You can define it to mean a precedent means a judgment of a court of law quoted as authoritative for deciding a similar fact. So, a precedent is a law. Court decides a case, and if another case of similar facts comes in place, they can use the previous case to decide the current case in issue. The doctrine of stare decisis is the one which establishes a precedent. Stare decisis means that let the decision stand. We have the types of stare decisis. We have the vertical stare decisis and the horizontal stare decisis. Vertical stare decisis means that lower courts are bound to follow decisions of higher courts. Here is a specific example. All courts in Uganda are bound by the decisions of the Supreme Court. And horizontal stare decisis means that some courts, certain courts can follow their previous decisions. Take an example like the High Court can follow its previous decisions in deciding a later similar case with similar facts. So, we are now going to look at parts of a judgment which lead to a precedent. These ones are ratio decidendi and obiter dictum. So, what is ratio decidendi? We have discussed these two on our channel. You can look for them. So here we are going to just polish. Ratio decidendi means that the reason for the judgment, the rationale for the judgment, it is the core of judgment. The ratio decidendi is binding. To give an example of ratio decidendi, a reason for judgment, in the case of DPP versus Vesige, Justice Katusi, before acquitting Vesige for rape, gave a reason for the judgment, the ratio decidendi. She stated that the evidence against Vesige was inadequate even to prove a debt, impotent to deprive of a civil right, ridiculous for convicting the pettiest offense, and monstrous as if to ruin the honor of a man who had offered himself for presidency. That was a reason for judgment. Now, let us look at obiter dictum. Obiter dictum, they are like the comments a judge makes, which are not connected to the decision, but they are persuasive, is connoting a situation relating to the judgment, relating to the case in issue. For example, in the case of Caril versus Catholic Smoke Ball, a case reported in 1892, Bowen LJ used the dog analogy to explain the unilateral offer more. He stated that if my dog is stolen, do I have a mandate and I write a note to the public that whoever finds my dog shall be given a prize? Does it mean that all people whose business is to look for lost dogs should write down a note to me that they have accepted my offer? Of course, no. So that dog analogy was not connected with the carbolic smoke ball, the product in the case, though it was persuasive to the decision. So now we are going to continue to see the types of precedents. These types of precedents are somehow many, but I'm going to highlight the vital ones. To begin with, there is what we call the original precedent, the binding precedent or authoritative precedent, the declaratory precedent, and the persuasive precedent. So, what is original precedent? This one is one which creates and applies a new rule of law. So, we are going to give examples of cases which brought in place original precedent. We have said it creates a new rule of law which has not been in existence. For example, in the case of Susan Kigula and 416 others versus Attorney General, the Supreme Court declared that the death penalty is not mandatory and can only be imposed on the discretion of the trial judge. That case introduced that law. And in another case of Attorney General versus Kabasguka Mike, a case reported in 2021, court held that civilians cannot be tried in military courts for non-service related offenses. You see now, these cases have created new laws which courts follow to decide laws similar cases with similar facts. If you continue to the case of Dr. Kizza Besigye versus Yoweri Kaguta Museveni, case number 1 of 2006, the Supreme Court of Uganda acted as the court of first instance on the first presidential election petition. That is now a law. The Supreme Court is now the first and the highest appellate court as regard to the presidential election petitions. Let us now look at the binding precedent. Here is another way of calling it authoritative precedent. For this one, are the decisions made by a higher court that lower courts are bound to follow in similar jurisdiction. For example, a decision of the Supreme Court of Uganda is a law and all lower courts are bound to follow them. Let us now look at another type of precedent, the declaratory precedent. This one is one which merely introduces the application of an already existing law. The law is already there, but there is no case that has talked about that principle. For example, in the case of Donju versus Stevenson, the principles of negligence were declared for the first time. And if you look at another type, the persuasive precedent, this one is one which does not need to be followed, but it is persuasive. It is put in place for consideration. The judge has the power to reject it or accept it. For example, decisions from other common law jurisdictions, e.g. the House of Lords in England. You get? Now, we are going to look at the advantages. Let us first look at how court can avoid a precedent, can depart from a precedent, the techniques courts use to get away, not to follow a precedent. We shall look at the skill of distinguishing cases. Courts can distinguish a case, distinguish a current case from the precedent by highlighting differences in that case. Let me give you a very interesting example. In the case of Balfour versus Balfour, and in Balfour versus Balfour, let me first use merit versus merit. In merit versus merit, the husband wanted to use the principle in Balfour versus Balfour not to pay his consideration to his wife. So the principle in Balfour versus Balfour was that married people do not intend to create legal bounds. But however, in Balfour versus Balfour, they never signed. But because the man was a soldier and his wife was sick, so he was in Sierra Leone and said and told his wife that I will give you some money to facilitate you in my absence. However, when he failed to pay, the wife sued, and the court said there was no intention to create legal bounds. But in merit versus merit, the two, the man and wife, made an agreement to sell their home, and after to complete their home, it was a mortgage. So the man told the wife, you pay the mortgage. After paying the mortgage, I will transfer the house, full right of the house to you. But later, the man refused. But the woman was very wise. She told him to sign when they were in the car. And now, that signature made the case binding to the man. And the court distinguished the two cases and said that you want to rely on Balfour versus Balfour. But in Balfour versus Balfour, there was no signing, there was no signature. So let us now look at precedents decided per inturiam. These are cases where courts considered a wrong law to reach on the decision. So court cannot rely on that precedent. Let us look at another one, declaring a precedent obsolete. Courts can declare a precedent obsolete due to changes in law, the society norms and values. Because you can bring a precedent of 1771. The law has changed. Things change. We live in a changing society. You can look at reversing. An appellate court can reverse a lower court's decision. This is through appeals. For example, the magistrate court can rule in favor of someone, say, and rule in favor of the defendant, but the plaintiff continues to appeal in the high court. And in the high court follows, the high court favors the plaintiff. That is reversing. Let us now see the purpose or the advantage of doctrine of precedent. So, the advantages and the purpose of the doctrine of precedent was stated by Sir George Jessel, Master of Laws, in the case of Re Hallett, 1880, Volume 1, Chancery, page 712. And he stated that the only use of authorities or decided cases is the establishment of some principles which judges can follow to decide similar cases before them. So we can look at other advantages. Precedent creates certainty and continuity in judgment. You are certain of what is going to happen. It creates continuity in judgment. It saves time because the principle is already there, laid down in a case. The precedents are practical in nature. They are based on real facts, unlike the legislation. So you can also say that the precedent helps to maintain the legal profession, the ethics. When lower courts follow the decisions of the higher court, there is that respect. The doctrine of precedents also promotes equality before the law, because the precedent, the court shall follow the decision of another court. There shall not be cheating. The doctrine also provides details of the case. So now, to look at the disadvantages of the doctrine of precedent, you can see that the doctrine of precedent does not respect separation of powers, because it gives the judiciary power to make laws, because a precedent is a law. You can look for other disadvantages. I thank you very much for watching our videos. Those of you who have not subscribed, subscribe such that we move together. This is Legal Mindset at the Bar.